All right, welcome back to the House Environment Committee. We are going to shift gears and do a walkthrough of, I actually don't know the bill number
632.
of H 632, which is the DEC miscellaneous bill. This session with our legislative counsel, Mike O'Grady.
Good morning. This is Mike O'Grady, Legislative Counsel. You have seen many, if not almost all, of the provisions that are in H 632 already this session. You may recall last year in H 319, there was a miscellaneous environmental subjects bill that the department had requested that had addressed issues such as the extended producer responsibility program for batteries, the paint stewardship program, extending the deadlines for rulemaking under the Flood Safety Act, addressing other issues such as I think those are really some of the bigger issues that were in the bill last year. H 319 went to the Senate. It passed out of the Senate. It was on notice in the Senate, and there was an amendment offered to effectively restructure wetlands permitting in the state. The committee had it recommitted to its committee, and then the provisions of 319 were cut up and sent to other bills, or were just left in 319 as it exists in Senate Natural today. DEC came forward with basically a refinement of 319, not having those sections that went in the other bills. And that's effectively what's in front of you today, with some additional provisions that the agency also requested for this session. So with that, should I start walking through the bill?
Yes, and I think you may know, but Neil did a high level, tried to get him to sort of say the whys. And so folks may have questions for you based on what Neil was able to share with us.
Okay.
And then thought, and then we'll walk through this.
So on page 2, line 9, section 1, there was the creation of the extended producer responsibility program for batteries, and then a refinement of that in 2024. Part of the refinement required A&R to report back to you on how to address batteries that aren't really recycled right now, but do pose issues with disposal, including hybrid and electric vehicle batteries, battery energy storage systems, and batteries that are not easily removable from the products they power. You required A&R to do that permit. In conversations, A&R's conversations with the stewardship organization for the battery EPR program, the stewardship organization is willing to take on this report and this assessment. They just have requested that the deadline be extended by a year from July 1, 2026 to July 1, 2027. So you will see that the responsibility for the assessment is moved from A&R to the stewardship organization, and the date is pushed out 1 year. Otherwise, it is what you required for the assessment.
Remind me though, did we also added certain batteries with those updates? And so those, weren't we able to do that in that process? We're not waiting for those to get added.
Now, these aren't wouldn't fall underneath the program right now.
Right.
Like,
but in that, when we made those changes, I think we added certain batteries.
yes, you added,
That's staying.
yes, you're not changing the scope of the current EPR program. You increase the size of some of them, you increase the types of them, you combined the renewable and the non-renewable, or the rechargeable and the non-rechargeable together into one program. That all stays the same. This is just about how to deal with those batteries that are currently not in the program, but still pose an issue with solid waste management. You know, what are you gonna do with your Tesla battery that's your home storage battery in 15 years? And how is that managed? So that's basically what this is to address. Page 3, line 10. This is the fuel storage tank program, the above ground storage tank program. This is a tweak to the standard for providing that a fuel dealer shall not deliver a substance to a category 1 tank that is not up to standard. Right now, they can visibly say, it's not meeting the standard, we're not going to deliver to you. ANR wants to tweak this so that if it's not, it doesn't have a valid permit, which they should know already, or it's not meeting the current requirements for the tank for the tank, and it may result in a releasing a regulated substance. They just want to tweak this. This will allow them to more effectively red tag, especially before the dealer goes out, so they can check to see if the tank has a permit without having to go out and do the inspection or the delivery and then determining that it doesn't meet the standard.
Yeah, so we did have some questions on this. Does it apply to residential, commercial, all tanks, above ground, below ground?
Well, it's for category 1 tanks, and why don't I read that definition to you if I can get it up quickly enough.
The green books. Well, because it's the same one. It's titled 10.
So a category 1 tank means an underground storage tank except for the following: fuel oil storage used for on-premises heating purposes, or farm or residential tanks for storing motor fuel.
Motor fuel.
So it's not residential, it's not farm, it's your gas stations.
Yeah, okay.
Should I move on?
What was that?
Representative Morris.
What was that? Wouldn't be combined in with USD?
Pardon me?
They wouldn't, the fuel tanks wouldn't be.
It is a
collected in with
UST.
the US, yeah, it's a USD.
It is a UST,
It's a USD?
underground storage tank.
USD? I thought you were saying D.
P.
P.
Sound like
Oh,
D.
okay, I was like.
Okay, great, thank you.
It used to be LUST, but decided that wasn't the great
What did the L stand for?
leaky.
Although I have to say that would help us kind of in finding our way. So back to what this is really doing. Not having a valid permit.
This is one you should have the program in to tell you what the issue is, because it's a little wonky. It's a little wonky.
We will.
Page 3, line 19, section 3, there was a program funded through coronavirus state fiscal recovery funds that was called the Healthy Homes Initiative, that gave funds for repairs or improvements to drinking water, wastewater, or stormwater systems for low to moderate income individuals in manufactured housing communities. The information in that application and permitting was required by the federal conditions to be confidential. And it wasn't clear in the authorizing language that information needed to be confidential. So to ensure that the information is not disclosed under a public records request or similar access to information, the language on page 4, line 8 through 14 is being added, that all information submitted or compiled by DEC and the issuance of funding under the Healthy Homes Initiative shall be considered confidential unless the person providing the information designates that it is not confidential. And it's going to apply retroactively to that information that was produced or compiled from July 1, 2023 on.
Representative Hoyt.
Thank you. Are manufactured housing communities like mobile home parks?
Any other questions, Representative Moore?
Clarification from me. And I'll try to enunciate it correctly. What about a leaking septic tank? If a septic tank is leaking on a property and it could be proximal to another property, is that still confidential? Or
I mean, if you got funding through this program and the fact that you were funded through this program and your income or your other eligibility requirements under this program, that would be confidential. If you were going to A&R or A&R was going to enforce against you for a failed system, that would not be confidential.
right, yeah. Just the personal information more.
Right. So moving on page 4, line 17, the next 5 pages are all extensions of dates in the Flood Safety Act from 2024. So the first, that's section 4, is in the River Corridor base map. And that would push the map requirement for river corridors from January 2026 to January 2027. Similarly, on page 5, line 6, the requirement that DEC conduct education and outreach with municipalities, environmental justice focused populations, property owners, farmers, etc., regarding the River Corridor program and permitting of development within it, that would be pushed from January 1, 2027 to January 1, 2028. And then the report about that education and outreach on page 5, line 17, would be pushed from January 15th to January 2028. January 15th, 2027 to January 15th, 2028. And then on page 6, line 12, section 5, the required mapped river corridor rules for permitting of development in river corridors would be pushed from July 1, 2027 to July 15th, 2028. And then on page 7, line 12, the permit for development in a river corridor would be pushed from January 1, 2028 to July 1, 2029. And then on page 8, line 1, section 6, line 5, the reporting date for the study committee on state administration of the National Flood Insurance Program would be pushed from August 15, 2025 to August 15, 2026. The date for when A&R shall initiate the rulemaking for mapped river corridor and development within mapped river corridors is being pushed to July 1, 2028. And then page 8, line 16, section 8, the and this date is admittedly already passed. Will extend the date for rulemaking for net gain of wetlands from July 1, 2025 to December 1, 2025. And I don't know if Neil talked to you about that yesterday.
Very much. And so
We touched on it
He
overall.
didn't know the
We
status
did
of
not
it,
talk
and,
about the
and I,
specific
we need to get a
ones.
handle on the status of it, and so we'll have someone from the wetlands office in.
Okay, on page 912, you're now dealing with the clean water service providers. Do you need a summary of what the clean water service providers are?
Yes.
So underneath the Lake Champlain and the Lake Memphremagog TMDLs, there are waste load allocations that are not regulatory, meaning that they can't be achieved by ANR or Agency of Agriculture or AOT going out and saying, you regulated entity, you need to do this in order to achieve our waste load allocation. There are projects, stream bank stabilizations or culvert replacements, a lot of different types of projects that can improve water quality, reduce phosphorus to Champlain or Memphremagog. And the state needed someone to take on that responsibility or the coordination of completion of those projects. So clean water service providers are created for each watershed in the state. And those clean water service providers are directed and authorized to effectively find projects and fund projects to reduce phosphorus and improve water quality when it's not regulatorily required. Now, what is being changed here are the notice requirements for clean water service providers. Clean water service providers are effectively under current law regulated by ANR's default notice and comment. There's a chapter in Title 10 that says for this type of permit, you do this type of notice and comment. For this type of permit, you do this type of notice and comment. For general permits, you do this type of notice and comment. And they're referred to as type comments. Like you could have a type 1 notice and comment, a type 2, type 3, or a type 4. And what was done when the clean water service providers were initially enacted is that sometimes they had type 3 and sometimes they had type 4. And there's just been confusion about what type of notice and comment that they need to do. And you'll ask, well, what's the difference between type 3 and type 4? Well, type 3, you can have a public meeting. The interested persons can request that the agency have a public meeting. Type 4 is no public meeting because type 4 is generally for general permits, which you don't have a public meeting for coverage under a general permit. It's just usually.
So that's a pretty big difference then, that what we're being asked to do here, and I wonder, I don't expect that you would know, but maybe, like, how many public meetings were requested and what type of projects and.
I don't know. I think if you really want a true measure of these changes, you have to ask how the whole program is doing.
The whole type,
The
yeah.
whole clean water service
Oh,
provider.
that too, yes. Although this is because I was here when we made these type lumping changes, and now we're going back to days. It's ironic that we tried to true them up by calling them types and not having different business days and, whatever references throughout statute. Now we're going back to 30 days.
Well, 30 days is the default notice and comment for any time notice and comment is referenced unless otherwise specified. And under type 4, it's otherwise specified. Under type 4, it's 15 days. So you're actually increasing the amount of time of notice for the one where it's referenced as type 4, but you're taking away public meeting from those that are referenced as type 3. And so trying to true out, make them uniform, you're going to have to give or take in order to do that. Or you just say that they all need to be one type.
Thank you. Representative Austin.
Yeah, I'm just going back a minute. On page 8, section 8, the net gain of wetlands. Does the executive order impact that at all, that paragraph?
Yeah.
And how does that work? You always ask me questions.
I don't know because the net gain wetland rules haven't been enacted. The state policy in statute is that the wetlands of the state will be managed for a net gain. I don't know how that will be met with the proposal in the government's, in the governor's executive order and the A&R draft rules without knowing what the net gain rule would say. So I don't. Will they be required to meet the ratio for net gain? And if they're going to build in a unmapped class 2 wetland, is that subject to the ratio? I don't know. Don't know.
Does one supersede the other? Does the next executive order supersede legislative intent?
The short answer is no. The executive orders generally don't have widespread application and statutes control over executive orders.
Okay.
It raises a question about the, go there.
I mean, I shared the letter that you drafted for me and Senator Watson with the committee yesterday. It's posted to our webpage now. So if you feel, up to you, if you want to answer the question further.
But what I'm going to say is that Vermont is it's not unique, but it's one of those states that doesn't have a constitutional directive on how a governor uses executive order authority. And so it's implied from 2 or 3 clauses of the Constitution, the state constitution, the take care, the governor is directed to take care to implement the laws and administer the laws of the state. Separation of powers, that the powers of the administration, the executive are separate from the powers of the legislative and the judicial. And then there's a couple of more nuanced ones, but where does that power to implement and administer the laws end? And what does it entail? Does it entail, as the executive order on housing did, that the governor can direct the Secretary of Natural Resources to do things that are under the Secretary's statutory authority? It probably does, but in so doing, the governor can't direct the Secretary to conflict with statute or violate statute. And that's what the Attorney General's opinion effectively said in a very nice way. And so there's a whole dynamic there. And a part of that dynamic as well is that the authority that the Secretary would use to adopt the rules is legislative authority. You delegated that authority to the Secretary. It's your authority that you gave the agency to adopt those rules. Now, how they administer those rules is their authority. So that's why when rules are proposed, they come back to you to say, is this consistent with your statutory authority? Other states give their administrative rules committees the ability to veto rules. That hasn't been tested in Vermont, but we didn't draft our statute that way. The LCAR doesn't veto rules. It just objects to them, and that changes the standard if there's any litigation on that rule. But say you're in South Carolina, the legislature there can say, South Carolina Department of Natural Resources, we object to and veto your rule. But you can't do that in Vermont. And South Carolina court said that's because the authority is legislative. If the legislature granted it, if the legislature doesn't like it, how it's going to be implemented, then they can veto it. But we don't have that in Vermont. But I'm going afield.
Yes. Thanks to the
Thank
law.
you.
So back to clean water service providers and the notice, page 10, when implementing the requirements of the Secretary of Natural Resources, very key roles in the clean water service providers, one of which is developing targets for the watersheds that are going to have clean water service providers. And on page 10, the notice and comment that she would need to go through, that's being changed to a period of not less than 30 days. That's type 3. That would take away the ability to request a public meeting. Section 10, after a water is listed, the secretary has to propose a timeline for the development of projects in each watershed. So the timeline on page 11, line 7 is going to be specified as not to exceed 1 year. And any timeline or design life for a project is posted on the ANR's website. That's at the bottom of page 11, line 19. And then on page 12, line 9, when implementing those timelines or setting forth what the targets are going to be, the notice is moving from type 3 to 30 days. And then when implementing the requirements of sub C, it's moving from type 4 to 30 days. And so that's the clean water service providers. Then you get to stream alteration. If you are going to modify, alter, change, etc., the course, current, or cross-section of any water course in the state, you need to get a permit from ANR. It's called a stream alteration permit. And it's not for, you take a rock out of the water, you don't have to get a permit for that. You have to be moving 10 cubic yards or more of in-stream material in any year in order to require that permit. Now, when I first started, this permit program was limited to watersheds that drained an area of 10 square miles or more. And the agency said, we're missing things. We're missing alterations that are just significant because the watershed doesn't drain 10 square miles or more. So you took away the 10 square mile threshold, but going to any alteration is something, I don't know if Neil talked to you about this. It's causing administrative burdens for the program, having ambiguity for developers and others that might be doing alteration. So they want to change the threshold, not going back to 10, but going to 0.5 so that they don't have to go and look at every little movement of 10 cubic yards in water courses that really are not significant.
We're gonna have the agency in on this one.
Okay.
And you'll see that change, conforming change is made in section 10 and section 13 to define the scope of the water course subject to the permit. Section 14 is the stormwater section. You had this discussion last year with the agency. It's largely about whether or not the 3-acre permit should have stormwater fees. And on page 15, in the general authority for rules for stormwater runoff, they're striking the requirement that the standards include stormwater impact fees. And then in the specific 3-acre general permit on page 17, they're striking that the secretary has to allow the use of stormwater impact fees for that 3-acre permit. So you're basically removing the fee provision for stormwater permits. And I'm not sure if they intended it just to be for 3-acre, but the change on page 15, that's not just for 3-acre. And fees are a way that if you can't, they're either intending not to meet that load that can't be met through on-site measures. They're intending to either waive that, which they talked about last year for the 3-acre, especially for the residential sites. Do what you can on your site, and then we're gonna waive the rest of it. I don't know what they're intending here with that change on page 15. I get it for 3-acre. I don't understand it here.
Here would be for the whole universe of stormwater.
Yeah,
Yeah, including new permits.
yeah.
Yeah, okay, that's it. Did you want to comment on that?
Yeah. That just seems like not what we want to do. Especially at like large commercial industrial sites.
Right, yeah.
Yeah.
Okay, well, we're gonna hear more about this as well.
And there's a new head of the stormwater division. It's Kevin Burke. You know Kevin, you've met Kevin. On page 17, line 18, section 16. I know you did all of this last year, but EPA apparently provided comments at the last minute last year that they wanted changes, and now A&R is asking for those changes to the CAFO permit statutes. The first, page 17, line 18, section 16, this is just clarifying in Title 6, the agricultural title, that this permit in 4851 is a large farm operation permit. And remember, you can still be required to get a large farm operation permit because the LFO permit isn't just about water quality. It's about land use and vectors and et cetera. You can still be required to get that. But on page 18, line 18 through 21, the Secretary of Natural Resources shall direct a large farm to attain a NIPDES permit under 10 VSA 1263 if required by federal regs or a CAFO. So just distinguishing the first reference to the permit in 4851 is about the LFO permit. The second reference is about the NIPDES permit. And it's pretty technical. Then on page 19, line 4, section 17, you're moving out of the ag title and you're moving into the natural resources title.
Can I just roll back to the first change, which is the cow-calf pairs? Was that your change or the agency's change? On line 21, page 17,
That was EPA's
that's
change.
EPA's change. Okay.
Seems less clear than rather than more clear.
Cow or calf pairs.
So I
just like when Michael talks about this statute, so. no. Is it less clear?
So,
Or,
so do you know what that mark, which everybody calls Slash,
Hmm.
is not the guitar player for Guns N' Roses. It's actually called a virgule. And the courts interpret virgule to mean an or.
like that? You want to comment?
No, it strikes me that it should be an and, not an or. Cow and calf. It's a cow and calf pair. Right?
Equal equals an or by the courts. I just
Yeah.
needed to process that before we jumped ahead. Sorry, I'm a little slow today.
Yeah, I agree.
So when you see somebody say X and Y or Z/T, what they're saying is X, Y, or Z or Y. And there's a case out of Tennessee where the statute was written with a bunch of virgules and it let a drunk driver off. Because the ors, the court was like, well, that means an or. And then no, they were like, that means and or. And the court like, no, virgule means or. And so the drunk driver didn't meet all the criteria and they let him go.
So in this scenario,
Yeah,
oh, sorry,
thank you for bringing us back. Go ahead.
in this scenario, the pair has to be a pair of a cow and a calf.
Right,
Not
I,
two cows
right,
or two calves,
right.
but a pair of a cow and a calf. So I think in this case, maybe the virgule was not appropriately used in the first place. And I'm pretty sure if we ask the ag agency that this is supposed to say how, if we're going to replace the virgule with a word, it should be and. But we can ask the
Right.
agency.
Can you make a note of that though, Michael?
Okay.
Page 17. Glad I went.
I know this because I did a CLE presentation for on conjunctions. And, like, it was a lot.
I love it. Just like virgule.
Maybe you could edify us further at another time on that.
Yeah,
You'll have.
I have a great quote from Word on virgules. Page,
While we were interrupted a little bit, can folks, including you, Michael, stay after the top of the hour? Do we get through this or do we need to come back to it either? Do we need to come back to it after lunch? Or another time?
I can stay.
And 15 minutes?
Okay, hearing a lot of I can stays. Yeah. Okay, great. Thank you.
So you may recall you directed the agency to adopt a general permit for the CAFO permit for the CAFO program last year. And you required them to do that by December 15th, 2025. They have not done that. They've asked for an extension to September 1. 2027. And then on page 20, line 18 and 19, remember when I was talking to you about residual designation authority? It's like when the secretary and or EPA can require a permit whenever they want to, effectively. EPA wants that reflected, that a large CAFO shall not be required to have a CAFO permit unless one of the following conditions is met. The secretary determines in the secretary's discretion that a CAFO permit is required. That's already a authority right there. EPA wanted that reflected. On page 21.
Representative Chapin.
Just going back to the date change at the bottom of page 19, that seems like a really big change. And I guess I'm just curious if, this might not be a question for you, but is EPA okay with that change?
That's not an EPA request.
I presume not.
Yeah.
It's a year and, yeah, it's
Yeah.
a year and 9 months later. So I guess I just wonder if we should maybe find out the implications of that for EPA.
Yeah. Geez, what are they doing? Yeah, materials, killing us.
Can I move on? On page 21, line 4 through 9. Once a CAFO is covered under a permit, the farm is covered for 5 years.
Circle this day.
So this is really technical. It's moving from a farm covered by a CAFO permit shall renew the permit. It really is a CAFO permit shall be renewed in accordance with its terms. The renewal term will be in the permit itself. And then moving on page 22. This is language that I don't really know why EPA requested it. It was about the two or more individual farms that were owned by common ownership. If they were adjacent, they were going to be considered a single AFO. It does the same thing. It says two or more AFOs under common ownership are considered to be single AFO for the purposes of determining the number of animals out of an operation if they adjoin each other or if they use a common area or system. It's the same language. I don't know really why they changed it. It's the same effect. Page 22, line 15 and 16 for the mature dairy animals, whether they're milked or dry. You still have your dry cows on your farm. They're still going to be counted. And then for the next two changes, they didn't like the cross references to Title VI. They want the definitions to be specifically in Title 10. And so the definitions it's the same definition that was in Title VI. It's just brought in here, and then the same thing on page 24 for a medium farm operation. Instead of cross-referencing Title VI, the definition is here in Title 10. It's the full Noah's Ark. Nothing different really, except milked or dried, cow, calf, bears.
You see a problem with that just from a drafting perspective, or what is your thought on that?
You know, in our drafting manual, we're allowed to do it either way. One of the things that we have been doing more frequently is to try to coordinate definitions across programs and across titles.
Yeah.
But I can see what EPA is looking for. They're looking for the specific statutory authority for the delegation of this program. And they want it in one place. And I can see why they don't want to have to look. They want it one source of authority right in front of them. And I understand that, and it's allowable under our drafting manual.
Thank you.
It's not our current preference, but I get it. And then on page 27, you get line 6, section 19, going on to page 28, the powers of the secretary. She will specifically have authority to establish technical standards and require a CAFO to comply with technical standards that are consistent with USDA nutrient management standards, vegetative buffers, and any other CAFO requirements that comply with the Federal Clean Water Act and the enabling rules. And then there are specific references to certain federal rules that establish requirements, NPDES requirements for CAFO permits. And then section 20, you're in the CAFO permit requirements for A&R. This is really more of a technical change on page 30. In referencing the authority for there to be a directive to a CAFO to do certain management practices, they want to reference that it's as determined by the secretary or as specified in federal CAFO regulations. As specified in federal regulations and as determined by the secretary. And then section 21, this is probably something I should have done last year in making conforming amendments. This is the authority of A&R's appeals authority. And part of this authority allows the Secretary of Agriculture to ask the Secretary of Natural Resources to use the Secretary of Natural Resources Enforcement Authority against a farm. And last year, you got rid of the memorandum of understanding and you replace that with a document that outlines the process for implementing the subsection. And so I should have changed that. There's no more MOU. There should just be this document to implement the subsection. Section 22 is this almost the end. So the agencies are concerned that with the way that some of the federal programs are going forward and the amendments to federal programs, that the federal repeals or amendments could basically remove authority for the state programs. And I say that because many of the state programs, say the air pollution control program, it's largely dependent on cross references to the Federal Clean Air Act. And so if those cross-reference sections or rules are repealed, then the agency doesn't have a lot to stand on, because the cross-reference authority no longer exists. So what this does is on page 32, going on to 33. Well, first, do people know what emergency rulemaking is? So there's the Administrative Procedure Act for general rulemaking. It sets forth all the requirements that a public agency needs to do and go through in order to adopt a rule. They have to have notice and comment. They have to file with the Interagency Committee on Administrative Rules. They have to respond to public comment. They have to propose the rule to the Secretary of State and the Legislative Committee on Administrative Rules. They have to respond to LCAR's objections to anything in the rule. That takes, if you follow everything as fast as you can to the letter, to the day, to the minute, to the second, it takes 5 months. But it generally takes an agency 8 to 10 months to go through APA rulemaking. And it costs them, they say, $4,000. I don't know how, but it costs them $4,000. Emergency rulemaking allows the agency to skip all of that. They don't have to go to public comment. They don't have to do filings. They don't have to respond to anything. They go to emergency rule. Now, the emergency rule is just temporary and it can only be issued right now if there exists an imminent peril to public health, safety, or welfare, and may adopt a emergency rule. Or, and this one's a little antiquated, and this one is something that I was involved in. So the Migratory Bird Treaty Act, under that, you can only hunt those species and number of species, bag limits, that the U.S. Fish and Wildlife Service authorizes each year. They just issue those really late, like in like September, for a hunting season that starts in like October. And you can't do any rulemaking. And so we used to do emergency, we'd get the MBTA numbers and we do emergency rulemaking like 2 weeks to get the numbers. It was ridiculous. And so we allowed our state Department of Fish and Wildlife to do it by procedure, and it's so much better and so much easier. But there is this antiquated law in the emergency rulemaking that allows for a program to implement a federal statute through emergency rulemaking, which is what we were doing for the Migratory Bird Treaty Act. This is adding a third category. And so in addition to the grounds for imminent peril, health and safety, in addition to implementing a federal statute, an agency may adopt an emergency rule under the section if an amendment to a federal statute, rule, or policy will materially conflict with or threaten the ability of the agency to implement a statutory or regulatory program required under Vermont law. A majority vote of the entire committee, the Legislative Committee on Administrative Rules may object to proposed emergency rules for adoption under the substance. So Clean Air Act in, air pollution regs in Vermont, if the Clean Air Act sections are amended, say for motor fuel emissions, they'll be able to adopt a emergency rule to fix their rule so that's still implementable without that cross-reference to the federal Clean Air Act. Now, this authority would only be temporary, will be repealed on July 1, 2028. And that's that.
I have a question though. Page 28, there's a reference to the federal existing rules and it's kind of funny because it says current.
What line are you?
Yeah, I'm getting there, sorry.
Line 5.
Yes. Consistent with current US Department of Agriculture nutrient management standards, and then it references as such as, which seems kind of vague. And so I'm curious your thoughts on both of those, the current, because current can change, and then specific vague reference to existing federal regulations.
This is specific EPA requests.
Yeah.
But
But it seems to reference something that could change. And I guess I want to explore that, not right now, but I want your thoughts on it. It seems odd to me. I think their intention is what's in these rules now.
Right.
They could change.
Basically, I think they're saying that the secretary can establish these standards that are consistent with USDA standards or require CAFO requirements that are set forth under 40 CFR 412.4 and 123.26.
And
So when you look at the EPA rules for CAFOs, they are animal specific. Like there's a rule for pig CAFOs, there's a rule for cow CAFOs, cattle CAFOs. And so I think they're just wanted to get in their cross references to the dairy requirements.
which I think is great. I'm more interested in the moving target of federal
Okay.
laws and regulations, that topic in this one. So I don't know. It just seems, I think I want to revisit that thing.
Okay. And then the last section, last substance section, when the General Assembly required onboard diagnostic system inspection of automobiles during the inspection process, there was concern that the requirement to fix a car that failed would be too expensive for those of certain income levels. And you put into that, you created a program to provide vouchers to persons that qualified for repair of those vehicles that did not meet the onboard diagnostic system test. The criteria for income qualification you used was the LIHEAP standard and the standard at Department for Children's and Families. The agency is proposing to just be very specific about it and just set forth the specific voucher amount for the specific type of income eligibility. And you will see those on page 34, line 5 through 16. If you're not required to file an income tax return because of your income, you can get a voucher up to $2,500. If you have an adjusted gross income at or below 185% of the federal poverty level, you get a voucher up to $2,500. You're a Vermont resident with an adjusted gross income at or below 250%, you get $1,875. If you're a Vermont resident at an adjusted gross income at or below 300%, you get a voucher of $1,250. And then you have the effective date.
Representative Chapin and then Pritchard.
So, I'm not sure you said this explicitly, is this codifying in statute what the eligibility is currently under the most recent LIHEAP program, or is this a new set of eligibility?
It's a new set. I mean, it's, you know, the LIHEAP and the DCF things doesn't have the voucher amount max, right? And so this is going through and saying, if your income is this, then you get this maximum. But this is new and it's not in statute. This is session law. This is session law.
Representative Pritchard.
Yeah, so I'm just curious, and I don't know if you would know this or not. So is there any ceiling on that amount, or is there where is that budgeted? Where does that money come from?
It comes through your appropriation process.
Okay. Okay. Well, how does it know how many people qualify for that?
Well, that's part of the agency is going to have to go in
And provide.
with a request and with numbers to back up the request. And they might not get a full request.
All right, further questions? Thank you, Michael. Thanks for staying over, folks. And then we currently don't have anything for this afternoon, so
Could I just,
please, yes.
one last thing, in my presentation on water the other day, I said one thing wrong. I said that Maine was a non-delegated state. Maine is a delegated state. Massachusetts is the one that's not a delegated state. And then I said that Green River had surrendered its work. They had applied to surrender. They haven't actually received the surrender yet.
It's their intention to surrender.
Well, I was told that there might be some wiggle room.
Okay.
Just wanted to get that on record.
Thank you. And thanks again for walking us through this and for a good week, everyone. This week of session. Don't forget to do your expenses and have a great weekend.
Oh, this is what?
Do your